Welcome to Panko Collaborative Law and Mediation and our pros and cons series, where we look at the advantages and disadvantages of various different legal processes. And in this video, we are going to talk about mediation and look at the pros and cons of this process. Let's start by understanding what the mediation process is, what it looks like, and how it functions. So it is a process for facilitating conversation. It's not a process where somebody makes a decision that is imposed upon the parties. Instead, it's a process where the parties come up with their own pathway forward, their own decision, their own outcome. And the neutral third party, who is impartial, is guiding the process, is facilitating this conversation, does not have any powers to impose a decision or tell the parties what to do, is instead there to help facilitate the conversation in such a way that the parties are able to speak to the things that are important to them. Mediation is an interest-based focus rather than on positions. And so what we mean by that is if there is some sort of a conflict, let's say the conflict revolves around a separation, and there are two parents and both parents would like to continue to live in the family home. So that's their position. So one parent will say, well, I should be entitled to live in the family home. And the other parent says, actually, no, I should be entitled to live in the family home. They're both expressing their positions and coming at the problem from a rights-based perspective. Looking at it through an interest-based perspective through mediation, we're wanting to understand what the priorities are for each party related to the family home. What are some of their expectations? What are some of their assumptions? Their assumptions about what it would look like if they continued to live in the family home, or their assumptions about what it would look like if they weren't living in the family home anymore. What are some of their concerns? What are their hopes and their goals for what the future will look like with respect to the family home? And as we uncover those very important interests that are at play, we get a better sense too of people's closely held values and beliefs and the things that they're afraid of and the needs that they have. And that creates the foundation for discovery of where the parties can have some mutual interests to build options from for ultimately getting a win-win solution. So in a situation where we'll continue to use the same example, where the parties maybe go to a third-party decision maker, like a judge or an arbitrator, and that third-party decision maker listens to both parents' perspectives and their positions and perhaps their legal arguments for why they should keep the family home. And maybe the judge decides, you both have kind of, equal entitlements here, and I can't really see why one should have the house rather than the other. So I'll just order that the house is sold. Now, I'm not saying that that would be the outcome in every situation, but that could be the outcome. And if that was the outcome, both parties would be very disappointed, and their outcome would really look more like a lose-lose as opposed to even a win-lose, where one parent was able to keep the family home and the other was told sorry. So in a situation where we're looking at it through an interest-based lens and we're trying to be creative around options, it's not like we're asking one of the parents to say, all right, you know what, I don't care about the family home, I'm going to compromise, I'll walk away from it in exchange for something else. I think that might be part of the negotiation, but what we're really trying to do is expand the pie and see what other options might be available to the parties where they perhaps might both be able to benefit from the family home, or better understand what's important about the family home that can be replaced with something else, that maybe that need can be addressed through a different residence that is not tied specifically to the family home. Let's say, for example, one of the needs that the party has, one parent has identified, is that they really like the location of the family home. So they feel like they want to stay in that family home because they have a need to be in that same neighborhood. Maybe the home is close to the school. Well, there may be other options for them to be able to be in a home that is close to the school, because it might turn out that that's what's the actual primary concern and need, as opposed to that particular home. So mediation is a way to come up with creative solutions. Now, with everything, there are always advantages and disadvantages. So let's take this opportunity now to consider the advantages, the pros that are part of a mediation process. The first one is the fact that the parties ultimately determine the outcome rather than having the solution imposed upon them. Thinking of our example where a judge or third party decision maker might impose the decision to just sell the family home compared to the ability for the parents to, or the parties to ultimately reach that conclusion on their own, because maybe they can see that the selling of the family home will address some other needs that they have, but they're not limited to that as a possible outcome. They can canvass other potential and more creative ways of handling the situation. They have greater control over the timeline for working through the problem that they have through the mediation process, and also to manage their costs. So they can say, this is how much, what our budget is to try to work through this. And we want to work through these problems within a certain time frame. And these are the days that we are available. Of course, I'll be subject to the mediator's availability, but that's different than in the court system, for example, where you have to work with the court's timeline, and a scheduling can be much more difficult. The costs are much more difficult to control. Mediation is a private and confidential process. So anything that's discussed in mediation couldn't then be used against either party should they ultimately need to bring a court application or be involved in some other type of formal adjudicative type of process. So it gives the parties the freedom to truly speak to what is really important to them without fear that somehow that would be used against them at a later date. This preserves the relationships between the parties and, in fact, can even help repair damaged relationships. Mediation is not therapy or counseling, but it's sometimes coming into a process where you can talk about your experience and the things that what you were interpreting about the situation and get the clarity. There could be some missing information. You might have some assumptions that you were basing everything on, that you get more information simply by being in that environment that has a mediator that is facilitating a really important conversation. And it may not be so important if this is a conflict between people who were strangers and are strangers and they're going to continue to be strangers. But often our conflicts come as a result of interpersonal relationships, like parents who have separated and they're going to continue to be co-parents long into the future. It might be a conflict between people who work together and they anticipate continuing to work together long into the future. So finding a way to sort out the conflict such that they can still maintain their relationship and potentially improve the relationship, this is one of the huge advantages of using a mediation process. But to be fair, let's also talk about some of the disadvantages. Mediation is going to work best where both parties want it to work. Sometimes people ask me, well, what's the success rate of mediation? And I can say in good conscience, it's 100% successful in every case where both parties want it to be. Because if you are both committed to utilizing mediation as your process to determine your pathway forward, it might take a while, it might be difficult, it might be emotional, but ultimately, if you're both committed to it, you will get a resolution. Now, if one person is committed and the other person isn't, then the mediation process, it's not designed for that kind of dynamic. So it can make it very difficult. And it can also be very difficult where there's a power imbalance between the parties. That power imbalance might come as a result of the history of the relationship. Perhaps there's a history of violence between the parties, or even dysfunctional communication styles that have resulted in an imbalance where one party seems to be the one that's always controlling the conversation and dictating the outcome. It could be a power imbalance as a result of status or roles. So if it's an employment situation and a conflict between an employee and a supervisor, well, that differential between what the supervisor is allowed to do compared to what the employee family can do that can feel like it's, it isn't balanced. It's not just that it feels like it isn't balanced, it isn't balanced. And so if you are contemplating mediation and you recognize that there's a bit of a power imbalance, and I mean, you might be the one that has the power, it's important to bring this to the attention of the mediator so the mediator can adjust the process to account for that power imbalance. Another potential disadvantage to mediation is that sometimes people just want to be told what to do, and a mediator cannot impose a decision upon the party. So if that is something that people are looking for, that they just want to be told what to do, mediation would not be the right process for them. Now, if you're needing more information either about mediation process or other processes, please don't hesitate to give us a call. We're only a phone call or email away. You can check out our website at www.commonsenselawyer.com. Give us a call at area code 306-975-7151 or shoot us off an email at admin@commonsenselawyer.com.